All righty, well, I'm going to go ahead and get started in the interest of time, and hopefully those folks coming in here will catch up to us, but I am excited to introduce our topic for today. I am Diana Murray with ASAP Accounting and Payroll, and we are here to present Colorado labor law updates with attorney Michael Santo. So let's go through a few introductory slides first. Michael, if you'll go ahead and advance the slide. Great, and just a quick, I think, I do have a lot of clients of ours on this call, but just to give you a few tidbits about ASAP Accounting and Payroll, we are a outsourced payroll processing and bookkeeping firm. We have 3 offices in Colorado, Golden, Durango, and our home office in Telluride. We have 32 professionals and about 900 plus clients. We just processed 11,000 W-2s for 2020. Woohoo! So anyhow, we are your regional firm and are excited to provide resources and guidance to small businesses in our region. And we'll go ahead and advance to the next slide. So in terms of what we're going to be covering today, and specifically what Michael is going to speak to, is specifically related to the Healthy Families Workplace Act, HFWA, as it relates to paid sick leave, as well as the public health emergency leave. We'll also talk about FFCRA as it relates to HFWA. We'll cover a tidbit on Prop 18 in the future, and Equal Pay for Equal Work Act, and Colorado Wage and Hour update. All right, and without further ado, I'm so excited to introduce you to Michael Santo of Bechtel, Santo & Severn. ASAP has had the pleasure of working with Michael for several years, and specifically assisting our mutual clients with wage and hour matters and counseling on day-to-day issues, preparing and revising employee handbooks. So in short, Michael's kind of a rock star in the realm of employment law, and we call on him often. And without further ado, I'll turn it over to you, Michael. Thanks so much.
Thank you. Thank you for the opportunity to talk to everyone today. Yeah, there's a bunch of laws we're going to cover today. As Christina pointed out, we're really going to, or I'm sorry, Christina, Diana pointed out, man, it's been that kind of day, Diana. As Diana pointed out, what we're going to focus on the majority of the time is going to be the Healthy Families and Workplaces Act. We're going to cover a little bit on the, as Diana mentioned, going to cover a little bit on the comps law, a little bit on Equal Pay Act, which yes is in effect now, and of course so is comps, but we're really going to focus on Healthy Families. So if you've got any questions as we're going through Healthy Families, shout them out. I've done a couple of these talks over the last month or so, and I have to say some of the best questions I get are folks who call me afterwards and say, well, what about blah, blah, blah? And I'd say, oh, that would have been a great topic. We should have talked about that way back then. So what are we dealing with? Well, Colorado Healthy Families and Workplaces Act, which I guess I've been told all the cool kids are calling it HFWA. I haven't quite warmed to HFWA, but always looking to make sure we're clear. I will try to use HFWA as frequently as possible. In a very shortened legislative session, and without question, the impetus being the COVID issues of this year, last year, the Colorado legislature in June of 2020 passed the Colorado Healthy Families and Workplaces. The governor signed it in mid-July. It went into effect. Part of it actually went into effect right away, which we won't spend a lot of time discussing. The majority of our time will be spent discussing that which went into effect on January 1. I just noticed this as I was getting ready for the talk, and I really should have changed this. I do say here it closely mirrors the FFCRA, which is the Family First Coronavirus Response Act. That's probably inaccurate. I would love to be able to change that. It made sense to me when I said that, but I'm not really sure I would say it does closely mirror. There's a lot of differences. One of the biggest difference is that prior to HFWA being signed, FFCRA had a lot of exceptions. Those with under 50 employees, those with more than 500, and principally those in the healthcare industry. Those all went away in mid-July for Colorado employers, and all of us were required to comply with the FFCRA from mid-July on. Now we are all required to comply with certain parts of HFWA. Smaller employers won't have to, which we'll get into in a second. Small employers don't have to address all of it until next year, but some of it they're addressing right now, so something to keep track of. So what are the requirements? Well, the requirements start out with, starting January 1, employers with 16 or more employees, other employers start on January 1, 2022, must provide employees with paid sick leave. So starting on January 1, those of you with 16 or more, there are two components to HFWA. There's the sick leave component, HFWA sick leave, which we'll be talking about first. The second one is HFWA public emergency leave. We'll be talking about that second. HFWA sick leave, you only have to comply this year if you have 16 or more employees. HFWA public emergency, everyone has to comply with the exception of the federal government, but they're exempted from that. All other employers are covered by HFWA public emergency leave, this leave right here, right now. 16 or more, HFWA sick leave. So we're gonna go over HFWA sick leave first. It's a very broad, this is not a COVID leave. This is not specifically related to coronavirus. As you'll see, it greatly expands on that. And it is, employees must have must be able to accrue leave, to take leave for their own mental or physical illness, need to diagnose, need for treatment, need for preventative care. All that is covered under HFWA sick leave. Additionally, it covers, HFWA sick leave covers employees taking care of family members, which is defined very broadly. You know, those related by blood, those related by marriage, civil union, adoption, individuals who you are acting as parent for. Also, individuals who your employees maybe have some medical responsibility for. So you have an employee who takes care of a person down the block, gives them care, provides them health care, takes care of them for maybe safety issues. They would be able to get time off under HFWA sick leave for that purpose. And this is why I say it's much more expanded out than just COVID. Individuals who are a victim of domestic violence, sexual abuse, need to assist family members on that. They are eligible to use HFWA sick leave as well. And of course, in an instance where the public official has ordered the closure of the employee's child school or place of care due to a public health emergency, that is a HFWA sick leave as well. So you can see some parts of it were borrowed from the Family First Coronavirus Response Act, but also some are new, the domestic violence leave. We've had that in Colorado for a while, but that was always an unpaid leave. Now it's paid. So keeping track of those issues. These are why they can use it. These two will be the principal ones. What leave are they eligible to accrue? Well, beginning on the date of hire or January 1, if they're already employed, employees must accrue 1 hour at minimum, 1 hour of paid leave for every 30 hours worked. And it says they're up to 48 hours or 6 8-hour workdays. That an organization can expand. You can do 480 hours, you can do 96 hours. Whatever you want to do, you can do, but it can't be set at a minimum lower than 48 hours. So keep that in mind, that they're going to be accruing 1 hour for every 30 hours worked. And we'll get into what that means in a second, but 1 hour for every 30 hours worked up to 48 hours. They can roll over time. So they, at the end of the year, in fact, they generally will roll over time, that 48 hours will roll from one calendar year to the next. The interesting thing about HFWA is not only is there a limit on the 48 hours of accrual, there's actually a limit on the 48 hours of usage. So if, for example, you allow your employees to accrue 100 hours of HFWA leave, you can though say, well, you may get up, Dave, 100, but you're only going to be able to use 48 for HFWA purposes, HFWA sick leave purposes. That's permissible. You can cap usage and you can cap accrual as an employer. Now, another way to do it is to just simply give the 48 hours. You don't have to do an accrual. You just simply drop in 48 hours into an employee's bank, if you will, and that's how much HFWA leave they have. How do you determine, and this was the Department of Labor for years had a manual that was entitled the Administrative Bulletin, and they've done away with that. And they're now focusing on only doing what they refer to as interpretive notices. Tend to be a little more casual than certainly the Administrative Bulletin, which was written more like a manual. There often feels like musings from the Department of Labor. They're available online. They've done 3 with respect to this law, really 2, but because 1 covered when we all had to give FFCRA leave. So getting questions on that from a lot of organizations who will say, well, no, last year in August, an employee had to go home and we made them use PTO. And I said, well, what about FFCRA leave? And they said, no, we're not covered. We weren't covered by that. Yeah, actually, you probably were covered by that leave once July 15th rolled by and the governor signed the law. So a lot of organizations are going back and having to recalculate employees' PTO bank because they should have been using FFCRA leave instead of PTO leave. Well, let's talk about HFWA, which is what the interpretive notice 6A talks about. That's not as relevant now because it was basically only good through December 31st. Let's talk about how employees accrue leave. As I said, they accrue 1 hour of paid leave for every 30 hours worked. The key with non-exempt employees, though, is it's hours worked. So if, for example, you have an employee who works 60 hours in a work week, they accrue 2 hours of leave. If they work 120 hours, they accrue 4 hours of leave, or whatever it is regular hours, overtime hours, any hours worked counts toward that accrual. So make sure for non-exempt employees, you're not simply stopping at 40. Well, Bob hit 40 and we stopped accruing. Not if he's non-exempt. Every hour paid, not every hour paid, because that may be vacation and things like that, but certainly every hour worked must be included in. Exempt employees, those employees who are exempt from overtime, you can cap them at the assumption that it's 40 hours of work. So you can say to exempt employees, non-exempt employees accrue leave based upon hours worked. You exempt employees, we're just going to assume that you work 40 hours. Or your regular schedule is 36, so we're just going to assume you work 36. If you do 40, and the employee works 80, they accrue leave as though it's 40. So for exempt employees, you can set a number of hours assumed to be work. Non-exempt employees, you have to use actual hours. It's a big distinction. This came out in the interpretive notice. And as I mentioned before, you can do a complete dump of the 48 hours if you'd rather. This is by far the biggest question I get, and frankly, it's not even close. The department did this as a benefit to employers because they didn't want to say you have to create a brand new leave on top of everything else you've done. They permitted organizations to, in essence, mush to cover HFWA under a current leave. Don't turn off your monitors just yet if you think, oh, phew, we're all good. Because there's been a lot of confusion by this, and I like to call it a rose by any other name. The way both the law and the interpretive notices provide is that organizations does not require additional leave if an employer's policy provides for paid time off, often called PTO, for both HFWA and non-HFWA purposes. So if you have a policy that that is going to cover both, that's fine. You don't have to create a new separate HFWA policy. You can put it under the PTO policy. But keep in mind, if you're going to do that, and I think most employers are probably putting them together, if you're going to do that, there are a number of requirements, because a lot of people will say to me, well, it's fine, because I'll ask, how's HFWA coming? And they'll say, we don't have to worry about it. We already give 80 hours of vacation leave, so it's totally covered. And I'll say to them, oh, well, I thought your policy delayed for the first 90 days of employment. I thought no one accrued leave. Well, they do. They don't get it for the first 90 days. Or maybe they get it, but they can't use it for 90 days. And I'll remind them, well, that doesn't comply with HFWA. Or they'll say, well, it's a vacation policy. And I say, well, do you have reasons for leave in there? Yeah. Do you have domestic violence, for example? Well, no, we don't tell employees why they can take it. Well, HFWA seems to say that you need to tell employees why they can take the leave. So yeah, just a PTO or vacation may not identify that. Another thing to keep in mind is that most of our vacation policies, most of our PTO policies do, and perhaps even I would say should, identify how that's paid upon termination. Well, now are you including HFWA accrual into what needs to be paid on termination? So these issues, and the law is clear, but the phrase that I always get back, and it's in all the articles and it's in all the publications, we don't need to provide HFWA if we've already got a PTO policy. I would add that covers the same things at greater or required. So for example, in at least the amount of hours with pay sufficient. So that means your PTO policy, if you're going to use it as one, or any policy you create, must give 1 hour, at least 1 hour for every 30 hours worked. So for example, if you say, well, employees accrue monthly, they accrue 10 hours a month, so that's fine because no one works 300 hours a month. Great, when do they accrue it? Well, they accrue it on February 1. Oh, what do they have during January 1? From January 1 to February 1? Well, nothing, they haven't accrued anything yet. That's a problem for HFWA, because HFWA requires once it's accrued, it can be used. So you would need to make sure that it's available to employees once it's accrued. And you need to make sure your policy identifies that. Additionally, to comply, to have your PTO policy work and comply with HFWA, you need to make sure that it provides for PTO for all the same purposes covered by HFWA. So don't just point to your vacation policy and say, well, this is all covered. Your policy should identify those 4 reasons that we talked about in the beginning for an employee to use leave. You'll want to have that in there. Under all the same conditions as HFWA, and all the applicable rules. So for example, carryover, accrued leave, notice and documentation requirement. If you have in your PTO policy that the employee must give you documentation upon request, that's going to violate HFWA. So you don't want to just say, well, we got a PTO policy that covers it. Well, doesn't the PTO policy permit you to get certification whenever you want it? Yes. Well, that's a problem because HFWA only allows you to do that if the employees miss 4 or more consecutive days. Can't do it until then. So if your policy is different than that, you need to make sure that the policy identifies that. Additionally, there are some anti-retaliation and some anti-interference rights in HFWA. Do you need to state those in your policy? I think it's a good idea. The law isn't particularly clear that you have to have it in there, but it does identify those issues and that we have to provide employees notices with respect to those rights. So keep in mind that if you're going to take that approach of, well, we've got a policy, you'll want to make sure that your policy, to borrow an old expression, walks like a duck, looks like a duck, and quacks like a duck. It complies with HFWA all across the board. Not just, it kind of sort of meets the accrual requirement. And then additional HFWA leave, need not. So one of the issues that it gets addressed here is a lot of organizations will say, well, Bob had a vacation plan for February. He burned all his hours that he had accrued for that vacation and then immediately came back and got sick with COVID. Do I now have to provide him more? Not under HFWA sick leave. Once it's or later, let's say, we'll talk about public health emergency in a second. Let's pretend the employee doesn't have any public health emergency. If they burn all their hours for vacation and they've got no hours for HFWA sick, because it was all part of one umbrella policy, you as an organization can say, well, there's no more leave to give, no more paid leave. You're out of paid leave. You've used your paid leave for other purposes. So keep that in mind as you're preparing those policies. Okay, we can also require employees to use it in hourly increments. And you can even do it in smaller increments if you want, but the way they're looking at it is in terms of hourly requirements. We've mentioned this, but the reasonable documentation, which we're going to get into a second, which is not my definition of reasonable documentation, but that's what's in the regulations, only permits that for 4 or more days. So you're going to want to make sure you go through that handbook to make sure there's no requirement in there for documentation sooner than that. For those of you out there saying, well, hold on a second, I'm covered by FMLA, Family Medical Leave Act. I can get an FMLA certification on potentially even the first day if someone's got a overnight stay in a hospital. Under FMLA, you may be able to get that under the FMLA to determine if the person qualified, but you would not want to do that for HFWA purposes to determine whether or not they qualify for HFWA until they reach the 4th day. What is reasonable documentation? Well, the Department of Labor has a different definition than I do for reasonable documentation. But basically, if the employee receives services from a provider, a document from the provider indicating that it's a HFWA qualifying purposes will suffice. But if the employee did not receive services from a provider or for some reason can't obtain the document, the employee is permitted to provide their own writing that the leave was a HFWA need. So for example, you got an employee who is goes out for HFWA purposes, HFWA sick leave purposes, and then says, well, I actually never went to the doctor. I needed to miss for this sickness. Well, then there isn't, all we're able to do at that point is perhaps ask the employee, would you send me an email to identify that you have taken leave for HFWA sick leave purposes? So if they don't go to the doctor, there may not be, it's not like we can force them to go to the doctor under Health and Families. By the way, for those of you, this is just coffee. So I think after, as I walk through HFWA, I maybe should move that to like a martini or something, but no. For safety related purposes, domestic violence, the same rules apply as above, indicating the need. It's a very low requirement for employees to provide that notice. Employers, we can't require any kind of signature. We can't require a notary. We can't require any form. We, of course, can't require them to disclose any details about health or safety information. But to the extent we do get information, we as organizations, and most of you are probably not covered by HIPAA because you're not a healthcare provider. Healthcare providers are covered with respect to their patients, but not their employees with respect to HIPAA. But in essence, the Colorado legislature in enacting HIPAA really made us comply with a mini HIPAA, if you will, because we do have to keep the documents as confidential, keep them out of the personnel file, must be just stored in another location, another file somewhere else where every employee doesn't have access to. What else on that? Yeah, its documentation cannot be required to take leave. It's only really for documentation after it. If you determine that, and then they went one step further and said, if you determine that the documentation is insufficient, you've got 7 days to get back to the employee to let them know that you didn't think the documentation was sufficient. And then after that, you have to give them 7 days to cure. So there's really are requirements, and I know a lot of organizations, we work with them, it will require employees to give the certification. Often it comes up in unemployment disputes. Our ability to get that certification has been greatly reduced under HFWA. Keep in mind, you're not required to pay out upon termination. You don't have to pay out at the end of the year. HFWA is in essence not vested to the point where it's the employees to take with them, unless it's covered under your policy. So for example, if your PTO policy identifies that you pay it out upon termination and HFWA is under it, you may have to pay out HFWA upon termination. So you want to make sure that your policy is very clear as to how you're going to pay that out. I've seen a lot of organizations develop policies now that say 50% of the time is sick leave and 50% of the time is vacation under our PTO policy. So we're only going to pay out the 50% that's vacation. I've seen employers do that. I've seen employers say, we're going to keep track of what you accrue under HFWA and we're not paying that. So you want to be very clear what your handbook says. I would also say you're going to want to really keep track of what the Colorado legislature does this year. I think I am betting lunches, and I made a whole bunch bet of lunches on the Proposition 118. That I think the Colorado legislature this year is going to address the vacation payout and the PTO payout in a new law. There are 2 cases right now at the Colorado Supreme Court on this, one concerning agreements and one considering handbook policies. So I think that, and the Department of Labor is not happy with either of those decisions. And so I think you will see the legislature take up a paid leave termination bill or something along those lines, clarifying some of the language that has been in place since 2004. Employers can roll over paid, unpaid leave, but they can limit upon up to 48 hours. I saw this question came up in an early pre-chat questionnaire, if you will, and it's a really good question. If an employee separates and they return within the first 6 months, we have to reinstate their whatever they had accrued under HFWA sick. That has to come back. Now, it doesn't have to come back if you've paid it out upon termination, and so you paid the 50 hours or 48, whatever you paid. You don't have to pay that out. You don't have to reaccrue that because, of course, they've gotten the compensation for it. But if you take the approach of, we don't pay out HFWA sick upon termination, or you do a 50-50, you don't pay out that amount. If the employee comes back within 6 months, we have to reinstate that paid sick leave that was not used during their employment. So something to keep in mind there. Diana's jumping in.
Yeah, sorry. Insert myself. That'll help. I have a question that somebody submitted as it relates to rehiring an employee. So if an employee leaves the company and returns, their sick leave balance is reinstated. However, is that within a year or a certain time frame? What if they come back 3 years later?
Good question. They have to come back within 6 months. So if they don't come back within 6 months, if they come back 3 years later, you certainly could, reinstate it. You're just not required to.
Okay. And then I have a few more questions, but I might hold off until you are concluding HFWA, and then I'll come back.
Okay, because we're going to jump on. So that was, now we've covered, was it right hand or left hand? Well, whatever it was. There was HFWA sick. That's what we've just covered. That's the accrued at 1 for 30 or greater, 1 for 20, 1 for 25, whatever you want to do. And you can do different accrual amounts for different tenured employees, certainly acceptable. You can do different maximum accrual amounts for different tenured employees, certainly acceptable. Now we're going to get into HFWA public emergency. And while the HFWA sick, which I just did, that is only for those 16 or more. HFWA public emergency is everybody. Diana's back.
Okay, sorry. That was probably my segue to ask just a couple follow-up questions that came in regarding regular. I can't get used to saying not HFWA, so I'll just call it HFWA. In terms of the employee count, if somebody has employees in multiple states, are you just counting the ones in Colorado, or are you counting the total employee count for the employer?
Ooh, I'm going to use my favorite attorney answer on that one if it depends. If you have separate operations in true separate operations, so you have an operation in Utah or Nebraska or wherever they are, New Mexico, and they're completely separate. They've got their own tax ID number. They've got their own, they pay taxes down there. They don't have anything to do with Colorado. I think there's an argument then that you don't have to worry about those employees. But if what you have is, like, for example, one or a couple organizations or a couple different groups within Colorado, and then you've got a couple employees in Nebraska, but they're assigned out of the Colorado. And you got a couple employees in Montana, and they're assigned out of Colorado. You pay Colorado taxes for those employees, or they pay Colorado taxes. I would lean toward including them in, and they would then be eligible for HFWA. The Department of Labor took an interesting approach, which I quite honestly have said in a number of talks, I somewhat disagree with, but it helps employers, so I love it, which is the law says that if you've got 16 or more employees, you're covered by HFWA. So I read that to say, if you had 15 on January 1, but hired your 16th on January 10th, or if you're a seasonal employer and you had 5 until the end of March, and then you brought back 20, I say I would look at the law as saying, well, that means you're covered because you now have 16 or more. Department of Labor didn't take that approach in one of their interpretive notices. They said that they're going to borrow the Family Medical Leave Act counting of employees, and that requires you to have 16 or more employees. Well, that requires you to look at how many employees you have for 20 or more work weeks. So for example, if you're a seasonal employer and you don't get that 16th employee until March 1, you got 20 work weeks before you're suddenly covered by HFWA. I'm not sure I'm buying that, but it's pro-employer, so I'm loving it. So that's what the DOL said, and it's in one of their interpretive notices. Just not to turn this into a constitutional talk, but keep in mind that the Department of Labor, who I just love, they were great friends, I always share Christmas cards with them, they do not have the ability to trump law. They don't have the ability to do something different than the law. Many of you may remember when the federal law came out, their U.S. Department of Labor came out with all these regulations about what it meant to be a healthcare provider. And frankly, the definition was really broad. I mean, not only could I think we, as a law firm, cover it, are covered by healthcare provider because we provide services to a healthcare provider, but I thought like Jimmy John's, who dropped sandwiches off at a healthcare provider, would be able to claim they're under a healthcare provider. I mean, it was really broad. And there was a lawsuit brought, and back on September 11th, 2020, the federal district court out in New York said, whoa, Department of Labor, that is way too broad. You did not have the authority to go that broad. It is possible here that someone may eventually tell the Colorado Department of Labor, you could not restrict an employee's rights. who worked at an organization for 16 or more. So that one may be challenged, but as of right now, they're looking at 20 or more work weeks. If as of January 1, you did not have 16 employees.
And kind of a related question there. And before I ask this next related question, I think, again, just to reiterate back to the answer there, it depends. And certainly as it relates to having employees in multiple states and their principal place of work, and as it relates to the labor standards for those respective states, just be careful and consult with an attorney or HR professional regarding that as it relates to payroll as well. So
I agree.
It's a whole, throw that out there.
That's a great point. It's a whole bunch of it depends. In every factors, everything needs to be looked at, how separate the entities are do they go back and forth? There's just a lot of analysis on that. Just be careful.
Yeah. Okay. Some related questions. I'll assume the answer here, but I'll let you answer. Does this apply to temporary employees that are hired as W-2 employees, not through a staffing agency, but hired as a W-2 employee?
Yeah, it applies. HFWA sick applies to everybody. It doesn't matter.
Yeah. Temporary,
full-time, part-time, PRN. If they're under your employee, if you're doing withholdings for them, you're giving them leave. The proportionality requirement for like part-time folks is already in the accrual at 1 for 30. So for example, you may have an employee who works 5 hours a week. It may take them 6 weeks to work the 30 hours to get an hour. They're still under. You may have seasonal folks. You may, whatever, if they're an employee, they're getting leave. I think it's really broad.
Then,
I even think like partners who maybe not taxed as employees, I would think they would fall under this. I mean, it is really, really broad.
Yeah, that makes sense. Does it apply to H-2A employees? And I'm going to throw in H-2B as well, but H-2A employees.
Yeah, if they're employed, and I mean, unless they're coming in through like an independent contractor agency where you're in essence contracting with that group and not the individual, then yes, I look at it as very, very broad in terms of who is covered by this. They did not have a lot of, as I read it, look at it very broadly.
Great. And then let me see here. Are the requirements based on a calendar year or anniversary or hiring date?
You could do it at any of them. It would have to be identified in your policy. I think most employers that I work with I can only think of like 1 or 2 who are still using anniversary date. Most are using calendar year just so that and we're getting to, most I see are using calendar year. The law does not define it. It has to be calendar. You are allowed to use your years.
Okay, and then I've got a tricky one, but I think this is pretty common in terms of what businesses are facing today. So this question looks like it's 3-part. Currently, we don't offer PTO, just vacation, and we say vacation can be used with 2 weeks notice. Is it legal to require some sort of notice? The problem is I see a group of employees who wants to go camping for 3 days, and they all call in sick using the HFWA pay to cover these 3 days off. How can I deny that?
Oh my God, are you suggesting people lie when they want to take off paid leave? Stunned. Yeah, that is the problem. HFWA has no delay requirement. There's no 2-week notice aspect to it. And so if an employee, and particularly if it's under 4 days, simply says, I got a sickness, I gotta go, and they've got the accrued leave, they get to go. Now, I mean, if the employee, it turned out to be lying, the classic case I always say is, they tell you, hey, I'm sick today, I'm just in bed throwing up or whatever, and I'm just never going to make it out of bed. I can't come to work. And then you see them, for example, at Country Jam, one of the Grand Junction's local country festival, on Facebook. Well, they're having fun. I would ask them, okay, did you lie to me? Because if an employee is flat out lying to you, well, we get into different areas. But there is no delay in HFWA. it's if they need it, they get it. So if you have a vacation, you need to think, well, if you're going to have just a standalone vacation, then you need to have a separate HFWA sick leave, which gives these accrual rights, or you need to create a PTO policy that does both vacation and HFWA at the same time.
Great. Thank you. We'll continue on now.
Okay, I thought I was waiting for the second and third part. Okay, so that's HFWA sick. Now let's talk about HFWA public emergency, which we're all covered by, and frankly, employees already have their leave available to them, which is that there is a notice or part of HFWA that we have to make available to all employees an additional 2 weeks of leave, up to 80 hours. I often refer to it as 80, but it's really up to 2 weeks of leave during a public health emergency. According to the CDLE's Info 6C, employers with 16 or more, fewer than 16 employees must provide for this leave, which is something we've already talked about. They're still covered. There was a whole host of things that we were trying to figure out before the first of the year. Are we under a public health emergency? Will we be on one January 1? The Department of Labor, there's no question the federal government declared we were under a public health emergency back in March, April. The state government has been declaring us under a public health emergency. Both were going into this year. The federal one is going to end in late January. The Colorado public health emergency is going to end in mid-February. But initially, the Department of Labor said those don't count. Those don't count because it's only a public health emergency that's declared on or after January 1. So both those ones don't count. You've got to wait for it to be re-upped or redeclared or whatever it's actually termed. They then reversed themselves on December 22nd and said, nope, sorry, we are all under a public health emergency on January 1. A new one does not need to be declared. So employees all get access to that 80 hours. What does that mean? I'm sorry, those 2 weeks. What the declaration means, what that determination means is that all employers now have to supplement every employee's bank or available time to ensure that they have time off for 2 weeks, up to 80 hours, for the reasons of the public health emergency. For employees who normally work 40 or more hours, that's assumed to be 80 or scheduled for 40 or more. If it's anything less than 40, so even 39-hour employees, you are able to do a percentage of that to figure out what they actually worked, what they're scheduled to work, or those kind of things. So if you've got a 30-hour employee, they get their 2 weeks off, but they only get 60 hours, where the 40-hour employee would get 80 hours. So keep in mind that the amount of leave is going to depend. If you've got someone working 32, it's going to be less than that of someone working 40. All employees are eligible for this. Now, here's where it gets tricky. You're like, oh, really? It's just getting tricky? But you may count against an employee's accrued, soon to be accrued public health emergency or the supplemental, the amount that is already accrued by the employee. So for example, if you've got an employee with 60 hours of HFWA leave, seems unlikely because it happened January 1st. But if you've got an employee who's got X amount of leave, you can use that as an offset, that 60 hours as an offset to the 80 hours availability. So if you've got an employee who's got that, so now two really important points on this issue, which is the big one is what can you use as an offset? What leave? Can you use leave that does not comply with HFWA to act as an offset. So for example, if you have a vacation policy that doesn't give employees the ability to accrue leave for the first 90 days, and then maybe accrues less than 48 hours over the year. Well, that doesn't comply with HIPAA. So there's a strong argument that you can't use that as the offset. In essence, a literal, very stringent interpretation, very structured, strict constructionist approach toward the law is you can only use those leaves that are just like HFWA to count as an offset to the 80. You can't use just all leaves. You can only use the HFWA leaves. Is there a thought that, is there an argument that no, it's really all leaves. It's not just the HFWA leaves. Sure. I mean, I certainly think that's a possibility. I would facetiously refer to that as future litigation issues because I think there is an argument that it has to be just HFWA leaves. You can't just use all leaves. Because, for example, if your vacation leaves require the employee to be there for 90 days, well, then they can't access this leave for the first 90 days when they may need that. So to count it as a, accrual or an offset on the HFWA emergency could be a problem. The other thing to keep in mind on this is less law, more day-to-day employer stuff. If you've got an employee, let's say you got two good employees, you got Alice and Bob. And Alice is the best employee. She comes, I always pick on Bob for some reason. I have no idea why. Sorry for those names, Bob. But Alice always comes to work. She got a sniffle. She'll come to work. Now she got COVID. She says so. But, she had surgery on her ankle a couple of years ago. She showed up the next day, put in a half day. She rarely takes vacations. She's got like 100 hours built up of leave. Now there's Bob. The moment Bob gets leave, Bob takes it. He hasn't had more than 8 hours in his bank since he started at the organization 10 years ago. He always uses his leave. So you're about to, explain to employees what their public health emergency leave available is. And you walk up to Bob and you say, Bob, you had nothing in any bank, so we're going to give you 80 hours. Alice, our really good employee who never takes leave, always shows up, works through anything. You've already got 100 hours. So frankly, you get nothing under HFWA public emergency. We could maybe see how Alice would be a little disappointed by that determination. Like, well, what are you doing? Are you encouraging me to use leave? Because if I had used leave, I would have gotten a whole bunch more. But now I can't. So keep in mind that, yes, you are allowed to use an offset on HFWA leaves against HFWA public emergency, but there may not be a lot of employees cheering in the aisles when you explain that to them. The leave will these 2 weeks of leave or 80 hours, however you want to refer to it, will be available for up to 4 weeks after the public emergency ends. So hopefully it ends on March 1, let's say. They will still be able to use HFWA public emergency those 2 weeks in the next 4 weeks, even after the public emergency concludes. These are very broad reasons. The other question I always get is, well, what if they used FFCRA leave? They use those 80 hours. Do they get another 80 hours? Yes. They're separate leaves. HFWA wasn't even in effect when FFCRA was going. Now, FFCRA is still around as a tax benefit, and not as a requirement. So yes, even if an employee used 80 hours in 2020, they get to use 80 more in this calendar year because it's under HFWA public emergency. It's different than FFCRA. What are the reasons? These are very broad. And so for those of you who were giving leave under the FFCRA, it's self-isolating due to positive diagnosis. That was under FFCRA. But even experiencing symptoms, seeking medical treatment with respect to the illness or public health emergency. So a much broader than under the FFCRA, the employee gets to take leave. The other thing to keep in mind, because a lot of people refer to this as COVID leave or something like that, this is not just COVID leave. If you'll recall back to even last summer, we had a number of public health emergencies in the state of Colorado due to fires. This is different. So employees would get 80 hours off if there were issues being caused by the fires. So for example, if they had lung issues and they were experiencing symptoms because of those issues due to the fires, they would have that 80 hours in addition to the 80 hours for COVID leave. So suffering from a pre-existing condition, public health official has deemed it unsafe to come to work. Caring for a family member, they have to be available. And unlike what the law says here is, unlike all the great documentation we got to get under sick leave, we can't get any documentation under public emergency. If someone is missing for a public health emergency, we have to take them at their word. There's no documentation that employees are required to do. I addressed this before, but just keep in mind, family member is very broad. It can be even someone they're taking care of down the street. Additionally, so we get this, you got your policy set up, and you put your 80 hours, made it available to employees under HFWA public emergency. They got their 80. They're still accruing under HFWA sick leave. So they're still accruing 1 for every 30 hours or whatever you set up, even though they've got the 80 over here. The 80 is now separate, or the 60 or whatever you put in there because of their schedule. So while they've got that 60, they're also got 1 for 30 they're accruing over here. And they may wind up with 48 hours over here under HFWA sick leave, and they've still got their 80 hours under HFWA public emergency. So something to keep in mind there. They're still accruing leave under the HFWA sick leave. That's what I say there. Oh, if there is a reason and they need leave for HFWA public emergency purposes, it first has to come out of that. So if you've got an employee who's missing time for these reasons that I identified here, they get time under HFWA public emergency pulled. Then if they run out of time under that, they would be able to pull from their accrued HFWA sick. But it first goes HFWA public emergency, then it goes HFWA sick, and then whatever other policies you may have. So just keep in mind that the first pull for example, COVID reasons would come from there. We can put an employee into negative accrual under HFWA sick leave if we want. It's an option, and you then may be able to get that money back, assuming you get the employee to sign off on that. Carryover leave, we've talked about before, it's the 48 hours. It's going to carry over to the next year. No paid leave is required if everybody is all shut down. Employees have the ability to request that they get a sense of how much leave they have available, how much leave they've already used. So don't forget, we got to keep track of that and make sure we're telling employees about that too. In addition to that, we have to supply each employee with a written notice, which I think is done through an employee handbook policy, and also display the poster, which the Department of Labor has a new poster out on it as well. So in addition, so another thing people will often say to me, oh, well, hey, our vacation leave works for this, or our PTO policy. I would say, don't forget that the written notice must identify that employers can't retaliate it against an employee, and an employer can't interfere with an employee's use of leave. Most of the vacation policies I've seen before this year, or PTO policies, don't mention anything about retaliation rights or interference rights. So you want to make sure before you just say, you got this one over here, that it meets all those other requirements. We talked about that. Oh, yes, questions on that, Diana?
Oh my God, my head is spinning. Let's
It's really
see.
only two
So
buckets.
even
I always say, you know, where it would have been easy if they had costly, if they had just said, we all have to put in a HFWA sick leave policy, and it can't be combined with PTO, or it can't be another leave. You just, all of the employers, you have to give this separate kind of leave. That would have been much easier, but unfortunately, it would have required us to just basically give all employees 128 hours. So I appreciate that they allowed us to do these offsets, but it did make it very confusing.
Okay, so just one quick question before we move on to the other topics. We haven't even gotten to the other topics, but I know this is everyone's hot subject these days. So I believe these two questions are related, so I'm going to try and combine them. But if an employee only gets PHE leave once, what if an employee is given 30 hours while awaiting and then has to quarantine again a month later? Does that mean once per incident or a total of 80 hours over time?
It's a total of 2 weeks. I keep saying 80 because I just always assume full time, but it's a total of 2 weeks for the public or health emergency. So if they go out for their family member and they take care of their family member and manage not to get COVID during that process, but then a month and burn their leave in that process, and then a month later they get COVID, we don't have any other. That's it. So it's just that one time.
Okay, gotcha. That helps. All righty. I think we can move on. Thank you.
Sweet. Okay. The one thing to keep in mind, there were 2 leaves under the FFCRA, paid sick time, and paid family leave. Employers are no longer required to give either of those, but if you do give those, you do get a tax benefit. Now, that is something I think I'm encouraging folks to work with their tax experts on how, if they have to give HFWA public emergency, how do we count that as FFCRA usage at the same time? So we run those two concurrently. I'm making payments under HFWA public emergency, but at the same time, I'm also making payments that will constitute FFCRA payments. And is it possible to then get a tax benefit for that? We have officially exhausted my tax knowledge, and so I'll let Diana and her group address that. I'm not going to go into a lot of why are you looking at me like what? That's all you.
I do have one more question, and this question has actually came up quite a bit, I feel like, with everything going on right now. But so let's say that a business has maybe an outbreak of a couple employees with COVID-19, but they want to close down for a period of time. Are they required to pay all those employees during that closure?
Yeah, there's a reference back here that, and I haven't seen this happen yet, but where to go? I thought I had it, that if the entire business is closed, we do not have to pay under HFWA public emergency. If the entire business is closed, I thought I had that somewhere in here. So make sure you're looking at that. That would be a reason for, I thought I had it in there. It's somewhere, but yeah, oh, there it is. No paid leave is required if an entire business is completely closed. So if you just shut the whole thing down, that takes care of public emergency.
Thank you.
Quickly on 118, Colorado Prop 118, I'm not going to go into a lot of detail on it, simply keeping you that come January 1, 2023, we are going to start, there's going to be premiums pulled, or we're going to have to start pulling premiums to fund a paid medical leave in the state of Colorado, which is going to start on January 1, 2024. Man, I won a lot of lunch bets as to whether or not this thing was going to pass. And it basically requires 12 weeks of paid family leave for the payroll. I put payroll tax, but you can't call it a tax, but it sure looks like a tax. An additional 4 weeks if it's for pregnancy or childbirth, so that's up to 16 weeks. The interesting thing, and as I said, this has got a couple of years before it becomes a requirement. The interesting thing, and I'm not being political here, I'm just simply, as I say, just reporting the facts. Certainly the Democrats federally have run on a couple of different things with respect to employment law over the last couple of years, last couple of elections. One, a minimum wage issue, who knows what will happen with that. But certainly paid medical leave has been on or near the top of the agenda. Now with all three branches of President, House, Senate in the Democratic control, will we see paid medical leave being required by the federal government before this even gets into place? That is certainly something that may be out there. So keep in mind that we've got HFWA we're dealing with. We've got paid FMLA coming up in Colorado under Proposition 118, and then we may have paid federal leave under this as well. So have an extra slide in there. So keep track of all those issues. HIF was the big one. We'll worry about, as I say, if Prop 118, we got 2 years on. So 3 years before we even have to worry about leave. So just something to keep in mind as you're developing policies. Start looking ahead, because you're going to need to give a whole 12 weeks of leave for most employers come 2024. A lot of leave. One other issue, of course, we're going to cover these two issues in the same amount of time we just covered that issue. And it's really the issue, two issues, which would be the Equal Pay Act and the Colorado Overtime and Minimum Pay Standards. Just going to hit the highlights on those. Yes, this was passed in May of 2019. It went into effect January 1. We're all covered by it. But I will tell you, there is a lawsuit if you want to keep track of it. There's a lawsuit trying to prevent the implementation. I have not seen any order on that yet, but it's been brought by a recruiting company. Right now, we're going. This is Equal Pay Act is required. Its requirements are basically what have been in the law since 1964, which is organizations can't discriminate based upon sex or sexual orientation with respect to wages, benefits, accruals. We walk through a couple of key issues, and really what it is not, this is not an analysis of your workforce compared to another workforce, your competitors, people across the street. It's only looking internally. And when you do look internally, you're comparing apples and apples. Widget makers all get compared. Flux capacitor repairmen all get compared with each other. They don't get necessarily compared across. So if you have like a one position, like just chief financial officer, that one may not have any comparisons. But so it's really important as part of this that you have job descriptions, because job descriptions are going to show which positions can be compared, maybe should be compared, and which positions are just completely unrelated to each other. And so this is the key here. For substantially similar work, you're really going to want to make sure your job descriptions are up to date. The key one of the keys on the Equal Pay Act is it basically dictates 6 reasons you can have pay differences. And if it doesn't fall under these 6, there can't be a pay difference. And these are the 6: seniority, merit, quantity or quality of production, geographic location, education, training, and travel. The 2 I hear all the time is, well, we pay differently because when this person came in, they negotiated a really good wage, and this person didn't. Not one of the reasons, not one of the 6. I also heard, well, when we were looking for that widget maker in 2018, no one could find a widget maker. So we had to give a couple dollars more an hour. Now, widget makers are a dime a dozen. Widget makers all over the place. So we give less. That would be a problem, because when they came in, or availability is not one of the 6. So we're really limited to those 6 reasons. I encourage organizations to identify which reasons. You can pick 1 reason, 2 reasons, 3 reasons, 4, 5, or 6, whatever works for you, whatever's available. Make sure that it's actually the case, because you have to show that each factor is applied reasonably. You can't, for example, say travel. We use travel as a distinction, and nobody travels. Geographic region, when everybody's in the same region. So you want to make sure you're using those, you're identifying those on your job description so that they can show employers, they can show employees what factors they use. Because those factors must count for the entire wage difference. This is a big point, and it's one of the keys to the law, and they made it a lot in the law, which is you cannot use any prior wage history, any prior benefit history. And it comes up, for example, a lot of places, like, for example, a lot of times our job applications will say, what do you currently make? Well, can't have that anymore. Or in an interview, you may say, so what are you looking for in this job? And the applicant says, well, at my current job, I make, whoop, that's a problem, because we can't know what they make at their current job. I have one organization I work with that says, well, we're trying, one of the reasons employees don't like to leave is because they they don't want to give up their really great accrual rate of their vacation. So we tell employees, we'll match whatever your accrual rate is. Great idea. I'm just not sure how you do that if you can't ask the employee what their current accrual rate is. So keep in mind that the law has greatly limited the information you can get from current positions or previous positions. So keep track that these are the 6 reasons that matter. If it's not one of these, or 2 of these, or 4 of these, or whatever you use, it's a problem. We talked about this. The other thing you really need to focus on is postings. This law requires you to post all promotion possibilities, all promotional opportunities to all employees on the same calendar day and prior to making the decision. How long? Well, that's up to you. I mean, think about if you were on a jury and you heard, well, Bechtel and Santo post their position, but they posted from, during the Bronco game, and only 1 person applied. What are the odds? Not going to be a really great, that I don't see a jury going, oh, it's no problem. On a Sunday from 2 to 5, perfectly available. So develop policies that that identify, here's where we're posting, here's how long we're going to post. When you post, you have to make sure that you're doing salary range, general description of benefits, and all those issues that is required in the posting. If you do external posting, those same things have to be posted. The one area I get all the time is people saying, well, Alice, we've been grooming Alice for years to take over this job. So we don't need to post, do we? I mean, everyone knows she's going to get it. Yeah, you need to post. You don't need to necessarily interview everybody who applied, but you definitely need to post, because you can't move Alice into that job until a posting occurs. And you go through that process. So make sure you're posting every position, same calendar day for all employees, and making sure that you're identifying your range and benefits. Additionally, the law, and I'm not going to go into the reason for it for the damages, but the law requires, as a way to limit potential damages, is to do a comprehensive and thorough pay audit of your workforce. Have an Excel spreadsheet. Here are all the widget manufacturers. Here's their sexes. Here's what they're paid. Here are our factors. What I say is the law doesn't require calculation. It requires explanation. So making sure you can explain, well, why did Bob get more than Alice? Why did Mary get more than Bob? If you say, well, it's tenure, seniority. Well, but Bob's been here longer. Or it's merit. Well, yeah, but Mary doesn't have as good a performance scores as Alice. All those issues need to be looked at. So making sure when you do that analysis, and this is required once every 2 years, but I really recommend that you do it every year. I would also identify in your handbook some Equal Pay Act language. I have a little blurb here. You can just cut and paste and drop in that discusses the equal pay. So that's the equal pay we are in right now. Is applicable, and so we're looking principally at posting every position, conducting a wage audit, and making sure that any differences in pay can be explained by one of those 6 reasons. Okay, quick just reference to the Colorado, excuse me, overtime and minimum pay standards, which is comps. It is our new wage law in Colorado. It's actually an old wage law, but they really changed a whole bunch of things in it. Went into effect in March. It covers pretty much every employer except of federal and state government. The keys with comps that you want to focus on is it appears that they could have a very narrow interpretation of what time worked means. There's an example, the actual language here seems to say it could be a minute or more. A lot of us have rounding of 6 and 10 minutes. So something you're going to want to work with legal counsel about, because it does reference the time off there. These are what constitutes time worked. Pretty much everybody is an employee. They're really clamping down on the independent contractor classifications. That's the old order. Where's the new one? Here's the new one, which basically said everybody's covered except for these groups. Generally, everyone's covered except for counties, cities, those type of corporations, special districts. Everyone else is covered. The big thing with comps, there's 2 big things, and one concerns salary and one concerns rest breaks. Those are the big changes. To be exempt, to be classified that you don't receive overtime, you have to meet 2 tests, full test. One test not going to work. You need 2. And one's a salary, one's a duty basis test. I have that information in here about what those are. By far the biggest change last year, well, before, actually 2 years ago, the amount of the salary was $23,000. It has gone up dramatically, and it's going to keep going up. Until 2024, you can see the progression. This year, if an employee does not make $40,500, they cannot be exempt. They have to be classified as non-exempt, which means they have to be paid overtime. You have to keep track of time. You have to make sure they're getting their overtime over 12 hours, overtime over 40. If they're under these amounts, that's required. So keep track. It's going to go up to 55,000 in about 3 years. So very large when all of us are going to be taking leave off under Proposition 118. So keep that in mind if you've got employees. 2020 we talk about here, but really that doesn't really matter much anymore because we're in 2021. Federal law is at 35,568, but of course that doesn't matter for us because we all fall under state law, or most of us do. So if you have an employee who's not earning $40,500, you have to switch them over to non-exempt. And next year, if they're not earning 45, you have to switch them over to non-exempt. Something to keep in mind there. The exemptions are really pretty much the same as under federal law. There's just a couple of big changes to them, and I wanted to highlight a couple of those. On the administrative duty, it's generally going to be someone who's got a lot of independent discretion and judgment, and they have to report to someone who is an executive, someone who is a CEO or a supervisor who qualifies under management or supervisor. So keep that in mind. So they got to get the salary, they have to report to someone who's an executive, and they got to have really high level duties. And so you'll want someone who is setting policies. For example, the organization I work with gave one of their buyers authority to buy $1.2 million worth of stuff without checking in with anybody. $1 million, a little more than $1 million worth of stuff. Didn't have to check in. And the Department of Labor said, that's not enough authority. Well, fortunately, we were able to convince them that that was wrong, but it is, the point of that story is it shows it's a lot of authority, not just some authority, I mean a whole bunch of authority. They got to be able to set policies without getting it approved. They got to really be involved. To borrow a line from the Broadway show Hamilton, which I love, they, in essence, got to be in the room where it happens. So keep that in mind. Ooh, good point. I love that. Keep in mind with respect to the executive exemption, the big change here, they have to, this is the federal one, but it works the same way, where they have to supervise employees 2 or more times, or 2 or more employees. The key here is in Colorado, they have to spend at least 50% of their time doing management duties, doing supervision duties. And so 50% or more. So these are those management duties. They have to spend 50% or more of their week. That means 20 or more hours in a work week. They've got to be doing each of these things to qualify under the executive exemption. The federal professional exemption is just like the state, so I'm not going to spend a lot of time. I'm going to jump ahead to, this is all in your materials that you'll get, but I want to jump ahead to by far the thing that created the biggest, I think, hullabaloo, if you will, is the rest periods. Lunch periods remain pretty much about the same. An individual, oh, here's the minimum wage. Here it is, meal period. Employees are entitled to 1 duty-free, uninterrupted meal period of 30 minutes or more when their shift exceeds 5 hours. They have to be relieved of all duties. If you've got your administrative assistant and you say, well, they eat at their desk and they only have to pick up calls if someone calls, but frankly, no one calls during lunch. Now, if they've got to do something, they're not relieved of all duties. So they also talk about they didn't want employers or employees, because employees love to do this too, tacking it on at the beginning of the day or tacking it on at the end of the day. It's supposed to be in the middle of the shift. They didn't want employees leaving half an hour early and saying, that's my lunch. That, the Department of Labor would say, is a violation of the law. If that's impractical, they can be given an on-duty meal period, but they cannot, they can't punch out. Don't do automatic deductions for meal periods. They're the source of class action lawsuits across the country. The number, I would say the number one source I see of class action lawsuits are organizations that say, well, we just automatically take 30, and then if they don't, they should come and let us know. That's how so many class action lawsuits get started, so don't do that. The other thing that's big here is the rest periods. They're entitled to 1 every 4 hours. I've got the chart right there on the slide. The key here is the employee, as you'll see in the beginning language, every employer shall authorize and permit. Authorize and permit is the key language. Not necessarily take, but the employee must be authorized and permitted to take a rest break. If they aren't authorized and permitted to take a rest break, we have to tack on 10 minutes on their schedule. So for example, you've got an employee who works a 4-hour shift, they don't get any time, they were not authorized and permitted to take a rest break. Even though they worked 8 till noon, you've still got to add now 10 minutes onto their day. So you have to pay them for 4 hours and 10 minutes, not just 4 hours, because they were not authorized and permitted to take that rest break. It's why we're encouraging organizations to identify in handbook policies, to identify in training, to identify in sign-off sheets that all non-exempt employees know they are authorized and permitted to take rest breaks. It's a key element of the law and source of, I think, a lot of litigation in the future. They're not supposed to be tacked on to lunch periods. As they say here, you can do 2 5-minute breaks instead of 2 10-minute breaks. Seems like a lot of work for me. But you do have to make sure that they're getting those 10 minutes or they understand they're authorized and permitted. Otherwise, the employee may be able to claim, I wasn't getting time off for my rest breaks, employer. And so you have to go back and pay me for all those 10 minutes I missed. Keep track of that. There's some new litigation on that that certainly made that interesting. Oh, the other thing under comps, we have to post the poster. So get online, comps order number 37, print that thing off. Make sure every employee has a copy, make sure it's posted. We've been recommending that organizations put them in their handbook so employees sign off the handbook, and you've got the comps poster in that handbook. So that takes care of the whole, did the employee get it issued? Post, 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 post is the way to look at it. So yes, I think I got done almost early, kind of early. Went through those last couples really quickly, so if anyone has any questions, let me know. But I really, with HFWA and the requirement for that new leave of the 80 hours, I really wanted to make sure we went through that in detail.
Thank you, Michael. I do have one follow-up question, and we were actually talking about this before the webinar, but in terms of the public health emergency order, and the expiration and renewals, what's the best way to keep track of that? Do they anticipate it being continued to be extended? Who knows? What's your take on it?
Yeah, I mean, my friend Google has been the way I have been trying to keep track of the where the orders have come from. The federal government is from the Department of Health and Human Services. The state orders have come from the governor. That Department of Health and Human Services probably is going to get extended in the next couple of days. I just can't imagine that they're not going to extend both of those for another 90 days, which will then give us plenty of time to worry about the next question on the agenda, which Diana unfortunately didn't put on there, which was, can we require all employees to be immunized? Which will be the source of many a gnashed teeth in 2021, and perhaps even beyond that. But I've been, the best way I've been able to find it, Diana, frankly, is just Googling Governor Polis public health order. I can't imagine he won't extend it. With the numbers the way they are now, it will most certainly get extended for another 90 days come March or February 10th or 12th or whatever that is. That's my bet.
Thank you, and that is that's a good segue, because I feel like sometimes the stuff that gets sent from the state can cause a head spin on its own just reading the emails, and so that is a good segue to sign up for Michael's employer advisory. I am a big reader. I print it out and read it thoroughly with every. So he has this kind of at the bottom of his screen here. It is a fabulous newsletter for employers, has a lot of good juicy FAQs that all of our small businesses come across. So go ahead and email that email address on the screen to sign up to get that newsletter. It
was so frustrating last year. You know, we've been doing that newsletter for 25 years, never missed a quarter. It's free, by the way, and never missed a quarter. Always got it out, give or take within the first couple of weeks, but always pretty near the quarter. Last year, we just gave up. There was no way. So frequently, we were just like, forget it. We can't do it. So we did our biggest newsletter ever in December. We wrote it, we finalized it, and we had to, after it was finalized, we had to change it 3 more times between final and when it finally got sent out, because the Department of Labor kept issuing changes. And so we could not even, last year, even if we said, it's a year end, we could not keep up with the changes. They were happening so frequently. So yeah, try to get that newsletter. We're gonna get back on the quarter because we're hoping things settle. And we'll keep you posted on
absolutely.
Certainly the federal issue, the minimum wage, is that gonna go up? The federal medical leave, Colorado's vacation pay, PTO payout, all those are going to be the hot button issues. Whether or not they're going to expand equal pay to include national origin, which was my prediction last year, we'll cover a lot of those in our newsletter. Thank you, Diana.
Great. Well, I cannot thank you enough, Michael. You have been an incredible resource to us and our clients. So thanks for your time today.
Glad to help. Talk to you guys soon. Stay healthy.
Take care. Be well, everyone.